Adjournment request, if any, from item number 1 to 4. From item number 5 to 20.
With consent of the auditor, I take mention item number 17, Your Chief. What may we assume for the day, Your Chief?
17.
17. Hearing.
These are the connected matters. How we can,
17 not connected, Mr.
17 is not connected.
Yes.
Okay.
This is, Manoj, can it come up on Thursday, Manoj? This is the matter where appeal has been filed from a habeas corpus petition, Manoj. I found out, Manoj, from 2012 to 22, it was taken up by a single bench, Manoj. On Thursday, Manoj, if it's possible.
Thursday is the hearing day again.
It's a hearing matter, Manoj.
It's a hearing matter. Okay. Thursday.
Deeply obliged, Manoj.
Obliged.
Meet please, Your Lordships. I'd like to mention item number 19, Your Lordships. BPCL is a party here, Your Lordships may not be invited.
Another bench.
Deeply obliged.
Lordship, with the consent of other side,
Then
I beg to mention item number 23, your Lordship. Lordship, can it come up on the 7th, your Lordship?
7th of
January, Lordship.
7th of January.
Obliged.
May it please your lordship. Lordship, I'm praying for adjournment in item number 18, your lordship, as the senior counsel, Mr. K. Chaudhary is out of session.
Adjourn.
Obliged, your lordship.
Any other request?
May I please your lordship? Lordship, with the consent of the other party, I beg to mention item number 21. Kindly adjourn for the day, lordship.
Adjourn.
And adjournment memo has already been given yesterday.
Adjourn.
Yes.
May I please, Lordship, I beg to mention for listing FPIL. I filed in yesterday because it is a matter of urgent matter regarding delimitation. Tomorrow, my lord.
Next week.
Monday, Tuesday, Monday.
Next week.
May I please, Your Lordship, I beg to mention one file on writ from the state of Assam, Lordship, that one another analogous matter is listing for tomorrow, Lordship, as item number 10.
What's the matter?
It's a tender, challenging the tender process, Lordship. On private respondent, that was the L1 has already filed a writ appeal, Lordship.
Some stay was granted.
Lordship,
Some stay was granted in.
stay was granted in that,
Yes.
obliged.
May I please, Your Lordship? I beg to mention item number 22 from the daily list. I'm for the appeal and lordship. I have taken consent for
Adjourn, adjourn.
My lord, may I pray for a fixed date? I am appearing for the respondent number 5 now,
Ask the court master.
in the first week of February. Any day. Obliged.
There is an interim order that will be continued.
Interim order, if any, to continue till next.
Lordship, highly obliged.
Daily list for orders item 1.
In this case, I have received the instruction. There was an inquiry as to abnormal contention of the PIL. On the basis of that inquiry report, my lord, they claim, my lord, 6 Anganwadi can center in that area. We have found, my lord, there are need of 3 Anganwadi center. That is why, my lord, on the basis of the inquiry report from the district officer, director has submitted the proposal before the government of Assam. And government of Assam has already submitted the proposal before the central government for strengthening of the Anganwadi center in the three locations. Right?
So what do you want?
My lord, I may be allowed to file an affidavit stating all these things, my lord.
Your lordship, till the disposal of this PIL, your lordship, I would pray for interim, your lordship.
Interim?
Yes,
What interim?
your lordship, as per section 5 of the National Food Security Act, your lordship.
Right.
May I read, your lordship?
Yes.
The children below the age of 14 years, your lordship, they are entitled for nutritional food, your lordship. And since
They
the
have
product,
already said that they have sent this proposal to the central government.
yes, your
State
lordship.
government has prepared the proposal and sent it to this central government.
Yes, yes, your lordship.
So this is the only final relief which you are asking for as an interim relief.
Yes, your lordship, but we have also prayed for supply of food grains till the disposal of this.
That's right, but once they have already sent a proposal for this sanctioning the Anganwadi centers, then let them think over it and then only we'll do that.
Lordship.
Mr. D. Sharma. and an additional senior government advocate Assam has submitted that the state government has already sent a proposal to the central government for sanctioning of additional Anganwadi center so that the deprived children may be provided the benefits of the various schemes of the state government, by various schemes of the central government, which includes supply of nutritious food items and the other facilities to the pregnant women. Full stop. Learned Council has submitted that, Mr. Sharma has submitted that some time may be granted to place on record the subsequent developments. Time date for is granted January, third week of January. Listed third week of January for admission.
22nd January. Item 2.
May I please to lordship in this matter.
Also, item number 2, 3, then my lord 5 to 13. These are all connected, my lord, arising out of the same judgment. Now, my lord, all the other side, my lord, opposition side, councils, they have appeared. I pray, my lord, so far as the delay part is concerned, that may be considered and all these appeals may be taken up immediately after the vacation. My lord.
Lordship, I am appealing on behalf of the respondent in item number 2, 7, 8, 9 and 11.
Yes.
All the matters have been amicably settled between the parties. So there is no locus standi to file these appeals. I have the settlement order. Lordship.
On that, my lord, lordship
This
will, my
is
lord,
for
let
item
my
2.
senior be there, my lord, let it be considered on the hearing day, my lord. So far as this part is concerned.
This is for
Five-
item number 2, Lordship, and
2, 7, 8, 9 and 11.
yes, Lordship.
But let the delay be condoned, my lord, they are appearing, my lord.
No, there is no locus standi, Lordship, because the matters have already been settled.
No, that instruction I have also got, my lord, that it has been settled. But the law still, my lord, that judgment still remains in their cases.
The law, whatever it may be, once the dispute between the parties have already been settled, we'll examine the law in appropriate case.
No, my lord, so far as my lord, the other case, my lord, 3, 5, 6, 10, 12 and 13, that will be contested.
I'm contesting.
They are contesting the case.
You are
Common
contesting,
judgment, my lord.
this settlement has not took place.
Ultimately, it will have to be
And
hard.
what about this item number 3? Who is appearing for?
I'm appearing, my lord, 3, 5, 6 and 8.
So service in almost all the cases have already been.
My lord, I'm appearing.
12, 13, no, 13. Yes, did one.
Item number
My lord, 5, 3, 5, 6, 10, 12 and 13.
12 and
My learned friend will appear.
I'm appearing.
Okay, go ahead.
Item number 7, 8.
For a delay, my lord, that may be controlled.
Yes.
Lord may hear only. Mine.
Just
Mine.
तो नाम तो कोई जल्दी से इधर item इधर नोट करो कोई भी होगा.
the matter comes upon for consideration of the IA number 355 2024 preferred in writ appeal number 1431 of 2023 and IA number 3630 of 2024 filed in writ appeal number 1429 of 2023. In these IA, the appellants, the applicants have prayed for condoning the delay in filing the writ appeals. Full stop. It is noticed that against the impugned judgment, several writ appeals have been preferred by the Securities and Exchange Board of India. And those appeals are listed today at serial number 5 to 13. Full stop. In those appeals, this court has already issued notices to the respondents and the matter is fixed today for admission. Full stop. It is stated by the council appearing for the sole respondent with IA number 550/2024 and
And Lordship, item number 2789.
in some other connected writ appeals that they have already settled their dispute with the Securities and Exchange Board of India. And therefore, the writ appeals, those writ appeals are liable to be dismissed on this ground alone. Full stop. It is noticed that though in some of the cases, the dispute has been settled between the SEBI and the private respondents, but in some of the appeals, the dispute between the SEBI and the respondents is still alive. Full stop. Learned counsel appearing for the SEBI has submitted that the question of law raised in the writ appeals is required to be determined, and therefore the matter, all these appeals along with two IAs be listed for hearing in the January 2025. Full stop. Taking into consideration the above facts and circumstances of the case, list these appeals, list these IA along with the connected appeals listed today from listed today at serial number 5 to 13 on
9, my lord.
24th of on 27th of January 2013, 2025. On that day, the issue regarding the settlement of dispute between the SEBI and the private respondents will also be taken into consideration.
My lord, may I pray, can it be taken up for hearing, my lord, on that day?
Hearing?
Hearing of the issues, because my lord,
Let
item,
them come, let them come. If it is possible, we'll hear it at admission stage
no,
itself.
my lord, today all the respondents have been represented. So at least the delay may be condoned and the appeals may be numbered.
Delay will condone on that day or even though, what's the problem? IAs, we have already ordered for listing those IA along with this appeal, so.
No, my lord, so far as my lord, few items are concerned, my learned friend has no objection regarding the delay, at least that can be numbered, my lord. Then it,
Don't go by these formalities. If
My-
the delay is to be condoned, we'll condone the delay at the time of hearing or also.
yes, yes, of course,
What's the problem in that?
obliged. But there is an interim that may continue, my lord, in item
Interim order,
5.
if any, to continue till next.
Obliged.
Item 4,
Lordship, I beg to appear for the appellant in this matter. I
Yeah.
had moved an early hearing application, Your Lordship, because the matter
There
was
is the
not.
adjournment slip, sir.
Lordship, I understand, my lord, but I still would like to pray if a date can be given in the matter, my lord, if 7th of January can be given, Your Lordship.
And there is a consent of yours also.
My lord, I had given the consent initially, but I was told that later they would like to press their application also. That's why, my lord, I'm fearing. My lord, and I,
Here, we have the adjournment slip with your consent.
my lord, I'm not disputing that, Your Lordship. I'm only requesting if a date can be given, my lord, 7th of January, if possible, Your Lordship.
And 7th of January.
Deeply obliged, Your Lordship.
for admission, item 14.
My lord, on the last occasion, my lord, your lordship directed to my lord appeared advocate general, my lord, he is out of station, my lord. May I request my
Here
lord,
and it conference. Who is appealing for the other side?
petitioner,
Have you informed them?
Mr. Dunn.
Have
Mr.
you
I have not informed my lord,
inform him and then come?
Mr. Daskukar.
Pass over for the time.
Item 15.
We file our affidavit yesterday. We file our affidavit in opposition yesterday.
Yesterday.
That is not on the record.
May I hand over the copy? We have got that affidavit with us. I may hand over your lordship the copy to your lordship.
Okay, give it to us.
और एक copy लो ना।
ये affidavit मंगवा।
May I submit? There are three principal issues in this petition, my lord. One is that Rule 36(4), my lord. It was inserted in the law drawing its power from Section 43, capital A. But Section 43, capital A was introduced in 2018. My lord, in 2018, there was a Central Goods and Services Amendment Act 2018 was passed, wherein several provisions were inserted or amended. And it was specified in Section 1 that the date of the notification of the various sections will be notified. And that has been the scheme of the things of the entire GST Act. In fact, when the GST Act came into force, Sections 1 of the CGST Act 2017 itself says that the various sections will be notified from different dates, and the notifications were issued. As far as my lord, Section 43A is concerned, capital A, there was never any notification for, my lord, bringing into force Section 43A. Notification was issued in 2019, but in 2019 also, when the notification was issued to bring into force various provisions of 2018 CGST Amendment Act, the Section 43 capital A was never notified. My lord, I will, show your lordship from the, my lord, the various notification and the Amendment Act.
That's another thing. First of all, this against this order, you have a remedy of filing an appeal before the appellate tribunal. Why directly to the High Court?
My lord, the reason is,
Yes.
well, two reasons. My lord,
Yeah.
one is that this is a constitutional issue, the validity of
Which-
Rule
Sir,
36.
You can very well raise this issue that since the 43A has not been notified, whatever provided in the Rule 36A is not
No,
applicable.
my lord, the validity of rule or the act, my lord, that can never be, my lord, raised before the tribunal or the appellate authority. That issue,
Without there being a validity, then why you have preferred this first appeal before the authority concerned? If you are so aggrieved by the validity, why you have preferred the first appeal?
my lord, we have raised the issue as far as the
So, sir, first of all, you have to satisfy that you are aware about that this provision is not valid or unconstitutional.
Correct.
Whatever it may be. Then why you have availed the remedy of first appeal?
my lord, the remedy was availed, my lord, two reasons. One is that in the order in original, my lord, they went beyond the scope of the so cause notice and raised a demand of.
Sir, this point which was now you are raising was not available to you at that time.
Yes, my lord.
This point which you are raising now, this validity part,
Yes.
this was not available to you at that.
No, it was available, my
It
lord.
was available, then why you have?
No, my lord, but my lord,
You are aware of this since
My lord-
beginning that this is invalid, then why you have not raised that point?
my lord, I have raised that Rule 36A, Rule 36(4). My lord, I gave the, my lord, I will explain, my lord, what I raised before the authority.
Yes.
My lord, what happened is, my lord, what Rule 36(4) says, that if my supplier has not filed his return, GST, my lord, there were two returns, my lord. One is GSTR1 return to be filed by my supplier, on the basis of which, my lord, there is a auto population in my portal GSTR2A, which reflects that who has filed GSTR1. With respect to the sum of the supplier, there was say 1 month delay. It does not mean that they never filed their GSTR1 return. They did file their GSTR1 return. Only point was that there was some delay on their part. And through a table, I described that say in the month of January, there is a negative because there are some suppliers who have not filed their return. But in the month of February, there is a positive, means suppose I am taking say 100 rupees of credit, whereas GSTR2A reflects 150 rupees. So that means the shortfall in January is set off by the February credit. So it is not that there is a loss of revenue to the department.
That is a point which what we are concerned about this. So that is a question of merit, whether it can be done or not. whether they have filed that return in the early later months, whether it would be treated as a this compliance or not, that's another thing. That's a matter of merit. First of all, why you have not raised this validity question when this impugned order was issued by the assessing authority or whoever the authority may be? You chosen to go to appellate court and you availed that remedy. Then again you filed a second appeal. That second appeal was dismissed purely on the not on merits and only on the basis.
No,
of
first appeal, my lord. I appeared before the concerned authority who issued me so cause
the
notice.
first appeal. You
No, that is not first
that-
appeal, man. That is the order in original.
that is the original in the now this second order by the commissioner. This is the first appellate court.
This is the first appeal.
First appellate court. Then why you have filed this? Why you have chosen to file this?
My lord, my lord, my submission is that this issue.
And this petition, this your whatever the appeal or what this commissioner has dismissed solely on the ground of limitation, without
Limitation.
going into the merit.
Yes, my lord.
Then now, if you are challenging this validity, this question was very well available to you at that time. Only because the High Court should entertain, therefore you have challenged the validity of this rule, sir.
No, no, that is not the reason, my lord. In any case, my lord, I will show that the appeal itself, my lord, was filed well within time and as per the rule.
That you can very well address on this point, that the appeal was filed in time and this has dismissed as wrongly been dismissed on the ground that it is beyond limitation.
No, my lord, but my lord, my submission is that your lordship sends me back to the appellate authority. But these three questions, my lord, which number one question, which is first time raised in the order in original. It was not there in the so cause notice, my lord. What they have done, my lord, section 50 very clearly says that the interest can be charged only on the cash component, not on the credit component. With respect to that also, my lord, in rule 88B was inserted by 53rd GST Council, which says that with respect to cash also, whatever was available, say I file my return, say with 3 months delay, but say as my money is available to me, I keep depositing money in my cash ledger. So the money keeps going into the coffers of the, my lord, the revenue. So earlier the provision was that irrespective that I have the cash with me, and I will refer to one Supreme Court judgment which says that the purpose of the interest is if the government is deprived of the revenue, if there is a delay. So, my lord, the government in its wisdom amended Rule 88. My humble submission is this, my lord, that this issue of the validity of the notification, my lord, or the section
What
88.
is troubling us only one thing, this ground was very much available to you, but you have chosen to file an appeal. And when the appeal was dismissed, then you have raised this ground. So why? What is
Correct,
this?
my lord. But my humble submission with respect to answer that, my lord. Well, to answer that, my humble submission is that this is my lord, if it is a validity, the issue of the validity of the rule or the applicability of a notification, my lord, it is a issue of jurisdiction, my lord. It can be raised at any stage, my lord.
No doubt.
Even if,
Then-
my lord,
Sir, no doubt, but the conduct Why don't we look into the conduct of the parties and who is telling the validity of the rule?
No, my lord,
Once the opportunity was very much there. You,
my lord, the way,
if this ground was very much available to you at that time,
my lord, I raised the issue before the authority.
knowingly that the validity part he cannot examine.
He cannot examine, correct?
Then why you have
My
raised,
lord,
sir?
my lord,
It was the
kindly,
adversary
my lord,
side.
kindly appreciate, my lord, no SSC, my lord, straight away wants to approach the High Court, my lord.
Sir, why? How can you say, sir? There are thousands of
My lord,
SSCs, they are directly
but
approaching.
most of the SSCs, my lord, there are SSCs who come to
Most
the
of
High Court
SSCs,
also.
thousands of SSCs are day in and day out approaching the court with
My lord,
the,
that is,
not even the validity part, they are trying to bypass that.
my lord, correct, my lord, but every SSC, my lord, every SSC, my lord, does not, my lord, go like that. They go by the advice of their consultant, my lord, whosoever is looking after their affairs on a regular basis, my lord.
If somebody has advised him, go to High Court, he would have come here. Somebody has
My lord, but
advised him.
he,
no,
the
no,
my
here,
lord, but my lord, the consultant who is my lord looking after, my lord, he must be aware of this validity aspect, my lord. He has raised it, my lord. I will show, my lord, that he has raised it before the.
Knowing this, that the appellate authority has no jurisdiction to go into all this validity of that, sir. It is not clothed with that power, sir. That is the
My lord, what happens is, my lord, that
we are not saying that this validity part is absolutely illegal, but we have to go by the circumstances also, sir.
my lord, today, my lord, if this liability remains on me, then what is the remedy to me, my lord? I will have to again come to the court only. What is the remedy to me to solve this particular issue? Or my lord, there are thousands of SSCs who are similarly situated, my lord.
Sir, have you replied regarding this validity part?
My lord, he has replied, my lord. I will show.
I don't think so. It's
No, my lord, he has replied paragraph 9.
paragraph 9.
Paragraph 9, my lord.
Validity part, I don't think so. He has replied.
No, my lord, paragraph 9 he has replied. My lord, it is incorrect, my lord. It is incorrect, my lord. I will demonstrate that from the compilation. I will show.
Drawing power from section 43 as section.
But that is the main, my lord, my submission. That is the only submission, in fact.
And it is effective from the that.
That is incorrect, my lord. That I will demonstrate, my lord.
Consider it, okay, sir.
My lord, I will show, my lord, through the notifications,
Then
my lord.
consider it, sir. Having heard the learned concept of the parties and after taking into consideration the fact that the heard learned counsel for the parties. In this repetition, the petitioner has challenged
Your lordship is adjourning to some other date, my lord?
admitting, sir. We are admitting.
Yes, sir.
Yes. In this petition, the petitioner has challenged the what did they do? 31st of March 2012 passed by the
Well, can you refer to page 42, my lord, three main prayers, my lord, which I wish to draw your attention towards.
Just a minute. Let us take the order that please. The additional commissioner, CGST NC Guwahati. The petitioner has also challenged the order dated 12/2/2024 passed by the Commissioner of Appeals, CGST, Guwahati, whereby the appeal referred by the petitioner against the order dated 31st of March 2023 has been dismissed on the ground of limitation. The petitioner has also challenged the validity of Rule 36(4) of the CGST / AGST Rules 2017, claiming it violative of provisions of the CGST Act,
CGST and AGST.
CGST and AGST Act. Full stop. It is noticed that against the order dated 12/2/2024, the petitioner has a remedy to file an appeal before the appellate tribunal as per the provisions of section 112 in bracket 1 of the CGST Act, as well as Rule 1110, the read with Rule 1110 of the CGST rules. However, the learned counsel for the petitioner has submitted that since the question regarding the validity of the Rule 36(4) of the CGST AGST Rules 2017 cannot be raised before the appellate authority, and therefore this writ petition is being preferred without availing the remedy of appeal before the appellate tribunal. Full stop. Learned counsel for the petitioner has submitted that though the petitioner was aware about though the petitioner has a opportunity to challenge the validity of Rule 36(4) of the CGST AGST Rules 2017 at the first instance, when he approached the Commissioner CGST by filing an appeal before by filing an appeal against the order of passed by the additional commissioner. But he have chosen to file but he has not raised the question regarding the validity of the above referred rule at that point of time. However, learned counsel has vehemently submitted that the question regarding the validity can be raised at any point of time. Regarding the validity of a rule can be raised at any point of time, and simply because the the petitioner has preferred an appeal before the appellate authority, it cannot be said that the question regarding the validity of a rule cannot be raised. Full stop. Having heard the learned counsel for the parties, and after going through the material available on record, we are of the view that matter requires consideration, hence admit no need to issue notice to the party respondents as they are represented through counsel. List for the hearing in due course.
Lordship,
Here it is not.
the provision of the AGST has also been changed, but state has not been made party in this case.
Provision is, that is one and the same thing. If they, even if the state is made party, state will take a different view from you.
No, that is there. Lordship.
It's okay. And the same thing. We'll examine the
Lordship will give any specific date,
February. Monday.
February
13 February.
13?
February.
February.
Much of.
Password matter 14.
I'm sorry, Milord. I was not ready. Sorry, sir.
Asking for some time. That's why only whether he has informed you in the advance or not. That's why only we have asked.
No, actually, Milord, I was a bit delayed.
Right.
No, you are not informed. Yes.
Why you have not informed?
My lord, since, my lord, I have not seeking any adjournment, that is why, my lord,
You are
whenever,
not seeking any adjournment.
my lord, in the morning, my lord, but since my lord, my learned friend was not available at that time, my lord, before reaching, I would like to, my lord, inform
No,
him, my
you
lord.
sought adjournment in the morning that Mr. Sekia is not here, therefore matter may be adjourned. How you are saying I have not sought adjournment?
My lord, I have been waiting for him, my lord, for it to inform him, my lord, that is the problem. My lord, I'm sorry, my lord, extremely sorry, my lord.
January. Any date in January?
Obliged.
Item 16 for hearing.
Yeah, Lordship. My lord, in compliance of order dated, your Lordship, order 312, my lord. I have filed an amendment petition, my lord. Challenging specific, my lord, that provision, my lord.
Yes.
If Lordship permits, Lordship would like to have final objection. I mean, if it is.
Question, okay. Okay.
Well, other, only one, I have changed the pair position. I have only one changed the pair position. I have not changed it.
You have changed
The pair position only.
then fine, the plan not. Okay. Pursuant to the observations made by this court on 3/12/2024. An amended writ petition is filed on behalf of the petitioners raising specific challenge to the provisions of the Assam Service Revision of Pension Rules 2017, which as per the petitioners discriminates between the staff nurse having BSc nursing degree vis-a-vis the staff nurses having diploma course, having the staff nurses possessing diploma certificates. Full stop. The amended writ petition be taken on record. Copy of the amended writ petition be supplied to the counsel for the state during the course of the day. The state may file its reply to the amended writ petition if it desires so by the next date of hearing. List on
Lordship may grant us 4 weeks time.
4 weeks.
Yes, sir.
Your stand is already clear. And it's a very strange stand. Health Department has asked you to get this amendment. And the other agency has also advised you to amend the rules. And you people are.
No,
still
amend the rules,
thinking on-
rule means it's a service rule, amendment of the service rule, not the ROP rule.
Whatever it may be. Okay, service rules. Despite that, if you are not doing that, let us see. Based on 20th of January 2025 for hearing.
In the last week of that.
Yeah.
Last week of that.
It's okay. In vacations, they are going to reply. You have
Yeah.
enough time.
My lord, there's an office note, my lord.
Yeah.
There is an office note, my lord. Office note is there, my lord.
Office note is there.
My lord.
So we have already passed that. What is that?
My lord.
Office note.
Deep level.
Item 20.
This matter, this appeal relates to the regulation of the service of the petitioner, my lord. What happened, my lord? He was appointed prior to 1493, my lord. That is the policy that is, those who appointed as a master roll worker prior to 1493, their services have been regularized. But unfortunately, my lord, these two persons' name were dropped, my lord. It has been admitted by the executive engineer in his letter dated, my lord. I take your lordship.
Yes.
I'm showing, my lord. My lord, I take your lordship, page 54, kindly come. Annexure 3, page 54. With reference to the above, I have the honor to state that the name of two number of master roll workers of this division are not included in the approved list sent by you. The date of the joining of those laborers are wrongly quoted in the original list sent to you through oversight. As per the record available of this office, master roll workers who are engaged prior to 1493. However, one correct list is sent herewith for your kind needful action. Then I take your option correct answer. That is page 59. Page 59. Shambhu Roy and Amjad Ali. Their date of appointment is 1389. Then, my lord, in a similar situated case, Honorable Division Bench, page 29, has already allowed. Page 29. For one of the person, my lord. Other is before your lordship today.
Given a direction to consider.
Yes. The civil order I pray for.
What happened by the Ranveer Singh refused to give this order?
No, no, no.
Why the Leonard Singh declined to give this order?
No, well, I have, after this mail, I have submitted approach to the authority, my lord.
No, no. Here, this is a writ appeal
Yes,
against the order passed by the Leonard Single judge.
exactly.
So why the Leonard Single judge has not granted to you that relief?
I take your lordship the job, lord. Page 21, my lord, kindly. In relevant portion, page 22, my lord, onward.
Wrong with the Leonard single judge order, sir?
My lord, I leave everything. But one thing that it is being admitted by the department, that it is our mistake.
When? It
Then,
was admitted when?
Then this poor employee who
Sir?
gave his service for 30 years as a master worker
When-
should not be given the benefit of the government
We
decision.
understand, sir. When the department has admitted that your name was left inadvertently, when the department has admitted this,
2005.
2005?
Yes.
And you approached the court when?
Because I have made several depositions to them.
When you have approached?
My lord, I came to know this matter that in 2021 when I was retired.
After that?
After that I have done.
After that, any order for regularization can be given, sir, after the superannuation?
My lord, question is that when department admitted that yes, by mistake his name was not incorporated.
Admittedly, we admit this fact. But the question remains, after your retirement.
No, they have not considered. They said because it is the finalization was done.
After retirement, whether any order for regularizing the service of an employee can be given or not.
My lord, that has been given in the judgment that after retirement it cannot be reopened. But question is that, my lord, such a serious mistake is done by the
Sir,
department.
mistake.
And for their fault should I
Done in
be?
the year 2005, you approached the court in 2022.
My lord, I was not informed that my name was not forwarded.
That can't be a ground, sir. That can't be.
I leave it to your lordship, my lord. But we must keep in mind that a poorest of the poorest employee of the department who gave his toil lost 30 years
But,
has been
sir,
deprived from his
a
pensionary
person-
benefit.
A person who is not vigilant about his rights, the court can't come to his aid or
My
her
lord,
aid.
I think your lordship will appreciate one thing, a master role employee, what does he knows of his rights or wrongs?
That can't be the excuse, sir. Regularization part, after retirement, the Supreme Court has said, no, you can't do that. Once
But
the
if it-
employee is retired, this.
I think, my
excess
lord,
can't-
in all respect, when there is a mistake, it could be cured by the.
But if you could have come in time. Sir, up to 2005, when your similarly situated person's services were regularized, you kept quiet.
I was in the
Even-
presumption that since my name was also gone there, but they are saying that
So
by
how
mistake your
long-
name is.
2005 till you retired up to 2021, you kept mum. Then suddenly one day in 2022, you came here and approached the court, sir, where is my regularization? These stale claims can't be entertained.
I leave it to your lordship and whatever might be the outcome.
This writ appeal is preferred by the appellant. Being agreed with the order dated 2/8/2023 passed by the learned single judge in writ petition number 5508/2022, whereby the writ petition filed by the whereby the writ petition has been dismissed. Sorry. In the writ petition, the petitioner has made a specific prayer that the respondents be directed to regularize the services of the petitioner from the year 2005. As the services of other similarly situated muster roll workers were regularized. The petitioner has also prayed that all the that after his regularization, all the consequential service and financial benefits may also be extended to him up to the date of his retirement from service on 31st of 12/2021. The case, the appellant has projected, the appellant has projected before the learned single judge that he was engaged as a muster roll worker on 1/3/1989 and continued with the said engagement up to 30th of December 2021. Is contended that though the similarly situated muster roll workers have been regularized by the state government in January, when they were regularized,
2005, my lord.
which date exactly, if any date?
22/7/25, 2005.
In the year 2005, but the petitioner was left out. But the petitioner's name was left out inadvertently on account of mistake by the respondent authorities. It was contended that the name of the petitioner was not sent along with the eligible candidates, muster roll workers for regularization, and therefore his services could not be regularized along with the similarly situated persons. Learned counsel has invited the attention of the court towards a letter issued by the executive engineer concerned,
Yes,
dated
I'll show my lord just now.
28/10/2005 or what?
Yes, 28/10/2005,
28/10/2005,
Right. page 54.
and has submitted that the executive engineer has admitted that the name of the petitioner was left out inadvertently. Learned counsel has therefore submitted that when the services of the similarly situated muster roll workers have been regularized way back in the year 2005, the services of the appellants are also liable to be regularized, and therefore a direction be issued to the respondents of this effect. The learned single judge has dismissed the writ petition filed on behalf of the appellant on the ground that the appellant attained the age of superannuation in the on 31st of 12/2021 and has approached the court only in the year 2022. And 2022, but has failed to explain the delay in approaching the court. Learned single judge has also opined that after attaining the age of superannuation, the relief for the prayer of the appellant for regularizing his services cannot be granted. Learned single judge has placed reliance on the decisions of the Honorable Supreme Court rendered in Uma Devi, Secretary State of Kerala versus Uma Devi, reported in 2006 4 SCC 1 and ML Kesari versus Union of India and others reported in 2010 9 SCC 247. Stop. Having heard the learned counsel for the parties and after going through the material available on record and particularly taking into consideration the fact that before approaching the court with the prayer for regularization, for issuing a direction to the respondent for regularizing his services, the appellant has attained the age of superannuation in December 2021. We are of the view that the learned single judge has rightly refused to grant any relief to the appellant. Hence, we don't find any illegality and infirmity in the room order. Resultantly, this writ appeal is effective. No orders as to court.